Hello, everyone, and welcome back to our webinar series on the basics of the PCT. This is episode 3, and it's the first episode in 2026. I hope you were able to either live join some of the previous episodes, but just as a reminder, they're also available on our website, so you can also watch the recording if you missed the first 2 episodes. With this series, we wanted to focus a little bit on the basics of the PCT. And after we talked about some more general questions about patent law and the PCT, then some of the basics on how to file a PCT application, I wanted to turn to a subject that really makes the PCT a lot of fun, and that is time limits. There are so many time limits in the PCT, and it can be sometimes a little bit overwhelming if you're still new to the PCT, but it's really the core of handling PCT applications, to know the time limits and to respect the time limits and to do your work within whatever time limits apply. So with that, let's jump right in. And what we will discuss today is a little more theoretically what types of time limits actually exist in the PCT system. And then I will spend a little bit of time on some best practices for docketing all of these time limits and the critical importance, of course, of docketing time limits so that you don't miss them. Then I would like to address a little bit how exactly are time limits calculated in the PCT. When do they start? When do they expire? And then I would like to address the possibility of extending time limits, if that's possible, if that's even possible. And then, of course, the sad story of what to do if I miss the time limit will also be addressed in this webinar. Now, I can't talk about all the details that evolve around the time limits. If I were to do that, I'd probably be spending 2 days talking to you about this, and our webinar is really only intended to last for an hour. And I do want to leave some time at the end for Q&A as well. So I can't discuss all the details, but rest assured, we will have further episodes. The next one actually will be on ePCT. There's no date set yet, but that will be next. And then there will be still some other episodes. And of course, there's other information about the PCT if you want to get into more details on some of the things that we're discussing here. So starting out, I guess with the timeline makes sense, because that really highlights to you already that basically the PCT is full of time limits. So you see 12 months, you see 30 months, 16, 18, 22. These are essentially all time limits, and in this case, calculated from the priority date. I'll come back to the priority date in a moment. Now, again, I'm not going to discuss the whole timeline here. I might come back to it during my presentation, but that actually is just a little bit of a teaser to show you that the PCT life cycle is filled with particular time limits. So what type of time limits exist under the PCT? So I was trying to kind of conceptualize that a little bit. And there are different types of time limits that we have. And a classical, and probably the most classical one, is that you have a time limit of X months from the priority date. So priority date, of course, needs to be understood and defined. And we do have a definition of the priority date in Article 211 of the PCT. And the priority date essentially is defined as the earliest priority claim that you include in your PCT application. And if you do not include a priority claim, then it's the international filing date. So what's important to realize is that there is a definition, and that it's always clearly defined from the time of filing of your PCT what your priority date is. And as a result, of course, that also allows you already at the start to docket some of the most important time limits. So what are some of these examples of X months from the priority date? There's, of course, the 12-month priority period. In this case, it's basically from the earliest priority that you're claiming, and then 12 months from that, you need to absolutely file your PCT. Or 18 months from the priority date is our date essentially for publication. We should publish promptly after 18 months from the priority date. And 30 months, another super critical time limit in the PCT. That's your time limit to enter the national phase. Some of you might have heard some offices offer longer time limits, but 30 months is kind of the minimum standard that all designated offices under the PCT system need to offer you. So X months from the priority date. We also have another type of time limit that I would say is X amounts from a certain other date, and that's usually the international filing date or the date of receipt of the international application. So an example for that would be a time limit of 1 month from the date of receipt of the international application to pay the international filing fee. You actually, in this case, have an additional month subject to a possible surcharge, a late payment fee. But the basic time limit is you need to pay your fees within 1 month from the date of receipt of your international application. And another example of a time limit in this category would be 4 months from the international filing date is a time limit, for instance, to correct priority claims. Again, there it's a bit more complicated, that time limit under Rule 26 bis.1a, but part of that time limit is a 4-month time limit from the international filing date. What else do we have? X months from the date of transmittal of a PCT form. Now that's, again, a very classical time limit under the PCT. And I think the most classical example for that would be the invitation in the form of PCT RO 106, the invitation to correct a formality defect that the receiving office has found in your PCT application. And the time limit in this case would be 2 months from the date of transmittal of the form. So date of transmittal basically means date of mailing of that form. So it's not the date of receipt when you receive the form, but it's when the office has transmitted, sent the form to you. So this is very important to realize. Under some national laws, it might be different. It might, the starting point might be the date of receipt of something, but under the PCT, it's always the date of transmittal, the day of sending it out by the office. And now we come to the most fun kind of time limits under the PCT, and I'll call them combo time limits, even though that's not exactly an official term. But often in the PCT, we combine multiple time limits, and then you need to figure out of these multiple time limits, which one is the one that applies in your particular case. Now, isn't that a lot of fun? So classical example is the time limit to correct priority claims. I already talked about this, 4 months from the international filing date. So IFD is the shortcut for us for international filing date. So it's 4 months from the IFD or 16 months from the earliest priority claim or date that you have in your application. So between those two time limits, you need to see which one expires later, and that's then the applicable time limit. So you can see that this can be quite tricky in practice to figure all of this out. Another example is a time limit for, I believe that's for filing a demand. It's like 3 months from the date of transmittal of the search report and the written opinion, or 22 months from the priority date, whichever expires later. So again, you need to look at 2 time limits, and then you need to figure out which is the applicable one. Another example, 2 months from the date of transmittal of the search report, or 16 months from the priority date, whichever expires later. And then just to make it even more interesting, and in any event, before completion of technical preparations for international publication. So in this case, you might even have to look at 3 time limits and then figure out which one is the correct time limit. And all of this is the time limit for you to file Article 19 amendments. Article 19 amendments is a possibility to amend your claims and to get them published together with the originally filed claims. So yeah, these are admittedly the most complicated time limits in the PCT. But if that sounds all too daunting for you, I do have afterwards a slide showing you the PCT time limit calculator, and that's a little tool on our website that will actually help you calculate some of these time limits. But before we get to that, I want to spend a little bit of time talking about docketing. So, it's one thing to know the time limit, but you really need to record the time limits in a well-functioning docketing system that you run in order to ensure that this docketing system sends out a warning before and in sufficient time for you to take a certain action and not miss the time limit. We generally actually recommend that you have 2 independent docketing systems running at the same time. And that way, I guess you have an additional safety net if one of the docketing systems is not working. On the other hand, we also realize that any docketing system is really only as good as the person operating it. That's why we generally recommend that not only one person should operate all these docketing systems, but ideally you have a second person. So data entry, have another person review the dates you entered, and to verify that the date entered is the correct date. Obviously, also the notification from the docketing system ideally is not only sent to one person, but maybe to 2 to warn the person that needs to take action that action is due within a certain time limit. So really keep that in mind. It's not just having a wonderful IT system that would do all the docketing system. You also need the human individual operating that system to make sure that everything is entered correctly and dealt with within the appropriate time frame. The most important time limits in the PCT system, and those are the ones which I really would hope you never ever gonna miss in your future filings of PCT applications. They're actually all tend to be set based on either the filing date or the priority application. I guess mostly the priority date. And so the time limits I have in mind here is the 12-month to file the PCT after the initial filing of a national or regional application, and also the 30-month time limit from the priority date to enter the national phase. And since they're based, these 2 time limits on the priority date, and as you file, what your priority date is, you can already enter those in your docketing system. But other time limits, which for instance depend on the mailing, the transmittal of a particular form, or some other points in time, they obviously cannot yet be determined from the very start. So you need to make sure that as you receive certain documents, that you are clear on which documents you need to really also enter into your docketing system so that they trigger a reminder for actions to be taken. So I just noticed that someone was raising their hand, and I think we don't really have the possibility to allow you to ask your questions orally. At least I'm not sure whether you're able to. So I would invite everyone who has a question to please enter them into the Q&A, and then I'll try to take a look at the Q&A, which I'm just doing right now, and I see there is a question right there. So please, rather than raising their hands, please enter your questions into the Q&A section of, I think we're on Zoom. Yes, on Zoom. So I got a question here. When are amendments to the PCT rules published online? So basically, it's the PCT assembly that adopts rule changes to the PCT, and the WIPO assemblies, including the PCT assembly, meets regularly in July of each year. And the rule changes then contain certain transitional provisions, also indicating when they will enter into force. Currently, the most common entry into force date for rules is either 1st of July or 1st of January. We just had two rules come into force 1st of January, but it's actually more common now to have them come into force on 1st of July. So if rules come into 1st of July, we try to make sure that they're all published, of course, ahead of time. I can't say specifically when in each individual case they will be published, but usually at least a couple of months before will you have the official publication of these new rules published in the PCT Gazette, but also on in other places on our website. And if you really want to know as early on as possible something about particular rule changes, I would advise you to go to the report of the WIPO or PCT assembly that would actually also have an indication of the rule changes that will come soon into force. And that's probably the earliest that you see a publication of the rule changes. Okay, I have to close the Q&A because otherwise I can't actually see the slides that you're seeing, hopefully. And let's come back to the docketing. So I think I did pitch my case here about having a good and ideally two independent docketing systems up and running, and of course make sure that you enter all the relevant data. All right, I thought I would show you already the PCT time limit calculator, but I think it's on the next slide. So first, I will talk about how to actually calculate, or how are PCT time limits calculated. So this is a little bit complex if you actually read through the rules. I'll just go through it a little bit. And for the most part, it's probably not something you need to worry too much about because it's relatively obvious from the actual date of mailing of something, or you know, the months from the priority date. So usually it's not that complicated. The rules themselves are a little bit complex. So the starting date basically says in rule 80.1 and 80.3 that any time limit starts to run from the date following the relevant event. And relevant event could be the priority date, the date of mailing of a form, etc., etc. And when do time limits end? So most PCT time limits are expressed in months, and the time limit ends on the day with the same number as the relevant event in the next, or in the month that's at stake. So unfortunately, we should have had this webinar tomorrow. Tomorrow, if I'm not mistaken, would have been the 30th of January, and then I would have said, well, take the example of today, and 1 month from today would be 30th of February. And of course that doesn't work because there's no 30th of February. So the exception applies that where the same date doesn't exist in the month when the time limit expires, it's the last day of the month. So a time limit that starts to run for 1 month from, let's say, tomorrow, 30th of January, would already expire. And I hope it's 28th of February, and there's not a 29th of February this year, which I haven't double checked. But anyway, I hope you get the point. Be also clear that local time limits apply where the action needs to be taken. So if you need to respond to a particular form, it's when your submission reaches the office where you have to file this particular document. So let's say your receiving office, you need to respond within 2 months to the receiving office. It's date of receipt at the receiving office local time. Now, the PCT actually leaves it to each office to determine whether you always have time until midnight of the last day of the period, or it's end of the working day. To our knowledge, most offices by now apply a midnight date, but they are still free under the current regulations to also apply that, you know, anything needs to get to us by 6 o'clock end of business, and otherwise it's considered too late. And I included an example here of a relevant event date of mailing of a particular form. I use 2nd of April 2025, and then a 2 months time limit would then expire 2 months later on the same number 2 months later. So that's the 2nd of June 2025. Okay, so that all sounds a little complicated, but really in practice, it shouldn't be all that complex. And I see that there are some Q&As, so let me just quickly open those. All right. Okay, there is one question about to enter into national phase at 31 months. Yeah, so basically the PCT obliges offices to not touch an application before the expiration of 30 months. So the applicant has a secure window until 30 months from the priority date. However, some offices, and the PCT provides for that, offer longer time limits. It's free to offices to decide what time limit they wish to apply in this case. And many offices have also indicated that they apply a 31 months time limit. For instance, the EPO, the Republic of Korea, just two offices off the top of my head where I can think of, they apply 31 months. There are actually some offices that even apply a longer time limit, and they're free to do so. And information on that can be found in the PCT Applicants Guide, so I would refer you to that. And then for national regional phase, is it 30 months after priority date or after the PCT filing? It's always calculated on the priority date. So priority date can, of course, in some cases be the filing date, but that would be when you don't have a priority claim in your PCT application. Then the PCT defines priority date in a case where no priority claim exists as the international filing date. So there it would be the same, but in general, it's always 30 months from the priority date, assuming that there is a priority claim, then of course it's not the international filing date. There is no 29th this year either, I think. Okay, so maybe my example would have worked actually on the 29th. Perfect. Yes, that's true. I guess it's not one of these years where we have 29 days in February. So darn, I could have used my example of today. All right, I blew that. Sorry about that. My question relates to the priority document. I have selected that it will be delivered by applicant. Our national office currently issues only electronic documents, electronically signed. I cannot upload the document because system does not recognize the document. So that unfortunately leaves me with a need for some additional information, and maybe it would be easiest if you try to mail in your question. There is information at the end of this presentation where you can send your questions to, because I would need to know which offices you're talking about and which systems do not seem to recognize it. So ePCT, for instance, if that's the system you're talking about, only recognizes certain priority documents in PDF format signed by the issuing office as valid priority documents. The one office I can think of that where this would work is the USPTO. So if the USPTO issues a PDF signed priority document, an applicant could actually upload that priority document to through ePCT, and it would also work for, I believe, Portugal, but I would have to actually make certain of that for which offices it applies. However, if the office that you're interested in is not one of the offices that has officially notified us of this way of issuing priority documents, it might not have been implemented in ePCT, and as a result, you might be blocked from uploading the document. But we would have to look at this in more detail. So please, if you could send us an email, and we'll try to help. Okay. All right. Oh, I'm getting lots of questions here. So, but we still have time, so that's good. So how a change of priority date by an applicant could affect PCT time limits? That's a very good question. And I must admit, I haven't even included this in this presentation because I did try to keep it relatively basic. So you probably know that the only way to change the priority date in the life cycle of a PCT application, if either the applicant actively withdraws a priority claim or a priority claim is declared to be void by the receiving office or the international bureau. So something needs to happen to the priority claim. It's disregarded for one reason or another. And then the rules basically say any time limit which hasn't yet expired at the time where this disregarding of the priority claim happens, or this change in the priority date, which hasn't yet expired, will be recalculated based on the new priority date. So what's the new priority date if a priority claim is withdrawn? I guess it depends on the case. If you have multiple priority claims, then it would be the next earliest priority claim, which determines the priority date. And if it's a single priority claim that you're withdrawing, then it would become the international filing date. The international filing date would become the priority date. So very critically, only time limits which haven't already expired at that point would be recalculated. So what you can't achieve is, let's say you miss the time limit, and then you think, let's just withdraw the priority claim, then I have more time. Unfortunately, that would not work under the current PCT regulations. It would not allow you to late submit something if that time limit already expired before you withdrew, let's say, the priority claim. So next question is, are provisional application filing dates always taken into account in calculating priority filing dates? Yes. So provisional application, something that exists in the US predominantly, are seen as regular filing dates for national applications, and they would be considered then, if a priority claim is made based on such a provisional application, as setting the priority date in a PCT application. Okay, and I got someone sending me information here who probably either has access to the applicant's guide or to other information. So basically, essentially, the following offices issue priority documents in PDF format, and they would be accepted then also by ePCT to be uploaded. And the offices in question are Austria, Brazil, Czech Republic, France, Greece, Italy, Luxembourg, Portugal, Poland. PE is probably Peru, if I'm not mistaken, Singapore, and the US. So there you have the list. And this is actually something you can find on our website. So I'm not sure if that already answers the question that the one person had. If an application has been terminated due to failure to provide fees, can the national office reinstate under their law? I'll come back to that question, but the short answer is yes. The last word is always with the designated offices, and you can possibly convince a designated office to still accept your application, even if it was declared withdrawn during the international phase due to lack of payment of fees. If you have, for instance, a good explanation, let's take the example, you were hospitalized and therefore didn't pay the fees in time. This is not an excuse that can be made during the PCT international phase, but it could be potentially an excuse that's acceptable under national law. And in that case, the national office could reinstate your application. But you probably need some kind of an explanation, or at least an office that allows you the payment of a fee to revive your application. In which situation could an applicant claim two priority dates? In principle, there should only ever be one priority date, but you could have two priority claims. So you could file multiple national applications and then follow up within 12 months of the first filing with a PCT application, and then claim priority of both of those earlier national applications. And this is done in practice When, for instance, I don't know, you develop something, a tool, and then you file a national application on this invention. You then go back to your workbench and you work on it a little more, and you realize, oh, there's another element I could also, claim to be an invention. You file that also as an application. And then you decide, I want to combine these two things and file it all in a single PCT application. But you have to be careful that you file the PCT within 12 months of your initial application, but then you can make a priority claim to both of them. Okay, and now I'm through with the Q&As for now. So let me go back to the presentation here. Okay, I think I did cover this slide if I'm not mistaken. Okay, and now I finally come to the PCT time limit calculator. So this is something you can find on our website. It's a standalone tool, and it basically allows you and helps you to calculate certain time limits that apply under the PCT. Here up on top, I don't know if you can see my cursor, but there are some of the main time limits. Then time limits to correct a priority claim, to amend claims, file a demand, etc., etc. So if you click on these, and obviously it's not live here, it's just a slide, a screenshot, but it would open up different interfaces below. So I think I am on the main time limit calculator. So I would then need to enter certain data. I would need to enter my priority date, which is my earliest priority claim in my PCT. If I don't have one, it's the filing date. Then enter the international filing date. And I could then click on, I'm covering this on calculate, and it would then start calculating certain time limits. Another way of visualizing certain time limits that apply under the PCT is actually contained within ePCT. I'll let my learned colleagues speak, of course, in much more detail on ePCT in the next episode, but there is actually also a timeline that is made visual in ePCT if you have secure access to your applications in ePCT, and that would actually remind and show you some of the most important time limits, and it would show where you are today and which time limits will come up in the near future, etc. So also an interesting and nice little feature in ePCT. But if you just want to use the standalone tool or the PCT time limit calculator, that's also available to you on our website, and you can calculate all kinds of time limits. Now, one thing this calculator does not take into account is weekends, but I'll come back to the issue of weekends and that how weekends can sometimes extend certain time limits, and I'll talk about this in a moment. But if you feel a little bit uncertain about doing the calculations yourself, I would really suggest that you use the PCT time limit calculator to help you with some of these tasks. All right, and now we come to the interesting question, can PCT time limits be extended? And I would like to start with somewhat of a special case, and that's the case of an invitation from a receiving office to correct certain formality defects in a PCT application. So that's usually pointed out to the applicant by way of form PCT RO 106, and the time limit stipulated in that form is 2 months from the mailing of the form. I think we mentioned this already before. So it's one of the classical types of time limits, 2 months from the mailing of a particular form. And this is one of the few time limits that can actually easily or relatively easily be extended. The RO has the discretion to extend that time limit. So you get the invitation to correct the formality defects. You're not ready to submit your correction within 2 months. For most receiving offices, if you come 1 or 2 months late with a correction, they will very likely simply accept it as still timely submitted. Maybe an office could insist that you first request an extension of the time limit and then accept your late submission. But I think most ROs are not even going to bother to be so formalistic about this. Unless you're really, really close to international publication, there's a good chance a late submission will simply be accepted by the receiving office. Now, why do I say this so close to the international publication? Well, remember that receiving offices need to transmit a copy of the application and any correction that you submit to the international bureau so that we can prepare the application for publication. And I guess we also tell receiving offices, please make sure that we get all these things in time so that we can properly prepare international publication. If an office sends us corrections after publication, it will lead to a need to republish the application. And of course, we're also not too crazy about republishing all applications necessarily. So we do tell receiving office, please make sure you get all these corrections in order and send to us before completion of technical preparations so that we don't necessarily have to republish these things. But in exceptional cases, and if there is a situation where something couldn't be corrected earlier and the RO still accepts a late correction, we would of course go ahead and republish the application as corrected by the receiving office. And then I was thinking hard, is there any other rule that allows for an extension? And really, I don't think per se the rules really provide for it. But there is a case where offices are sometimes a bit lenient when it comes to the payment of fees. So I mentioned earlier that you need to pay fees within 1 month from the time of filing. And the RO should, in principle, if you don't do it within 1 month, then issue an invitation and you get an additional month and they can charge a late payment fee. So obviously, ideally, you avoid that by paying the fees within the initial 1 month time period. The rules actually do say if an office hasn't yet invited you or declared an application withdrawn for lack of payment, and if you send in the fees, then they will be timely considered. So you could say that's already a bit of an extension. But also the discretion that I see that ROs use sometimes is that they give you a little bit of extra time before they actually issue either the invitation subject to a surcharge or even worse, the decision to declare your application to be considered withdrawn. So possibly if you are set on paying the fees and if you call your receiving office and tell them, I'm about to transmit the money, can you please hold off a little bit? They do actually have the discretion to do that. So one could argue it's a case of where you could maybe get to a slight extension of a time limit under the PCT. On the other hand, most other time limits in the PCT are really fixed and cannot be extended, even with a phone call to the receiving office and saying, couldn't you make an exception? They're not supposed to extend other time limits. So for instance, a time limit to add or correct a priority claim, that's more or less set in PCT stone, if you so wish. So that cannot and should not be extended. Or the time limit to file Article 19 amendments. Basically, if you're 1 day late, the office, in this case, our office, the IB, will turn around and say, sorry, it's 1 day late and we can't accept it anymore. So don't take this too lightly with the possible extension of time limits. In many instances, time limits cannot easily be extended, at least here during the international phase. But maybe there are some other means. And I already talked about weekends and possibly also official holidays need to be mentioned in this context. So both under the Paris Convention, which applies to the priority period, and to time limits under the PCT, for which Rule 80.5 regulates this, there is a provision that basically says if a time limit expires on a non-working day or an official holiday, that time limit gets extended to the next day when that office is again open for business to accept filings of international applications. So that's kind of the weekend rule. And of course, depending on the country, the official holiday rule, and clearly that's something you can rely on. Now, whether I would always rely on that is maybe a different question. There's no harm in meeting a time limit a little bit early. There's only harm in missing a time limit. So I think these are more last resorts than something you should absolutely count on. And maybe especially those responsible for filing certain submissions shouldn't necessarily use all the weekends to still be able to submit their documents in time. But be that as it may, these rules do exist, and if you are in a situation where you're really up against a time limit and the end of the time limit is on a weekend, you can still take advantage of this non-working day rule. Another related subject I wanted to discuss here is to basically take advantage of what I would call healable defects. So when you submit something, it needs to be in writing, it needs to be signed, and maybe you need to submit certain documentary evidence with it in order to be valid. But sometimes you don't have all the signatures that you need, or maybe you don't have the evidence readily available, but you could already send in the initial submission without the evidence. And in most cases, in order to meet a time limit, it's really a good idea to make sure that you at least send something to the office that you need to send something to, even if not all elements are present in your submission. So for instance, you need to file a particular action, but you don't have the signatures. Well, you can add the missing signatures later, and that's a healable defect, and it basically will be considered as having submitted in time. The only exception to that is notices of withdrawal. The outer time limit to file a notice of withdrawal is 30 months from the priority date. If we don't have the signatures within 30 months, we will not take action on the withdrawal, even if you furnish the signatures later. For all other things and all other time limits, arguably, it still makes sense to send in your notice even without a signature, and you can furnish the missing signatures later. Or think of a 92 bis request where a new applicant wants to be recorded as the applicant and the old applicant to be removed. For this, we usually need proof or evidence that there was a transfer of rights from the old to the new applicant. If you're up against the time limit, you can submit this request and furnish the evidence later, and it would then still be considered timely received if, of course, you eventually furnish the evidence. Maybe not exactly the same category is an issue with the priority document. So the priority document needs to be furnished ideally and usually during the international phase and within the applicable time limits of Rule 17, which, let's say if you file it directly with us, is up until international publication. But if you miss these time limits under Rule 17, there's also a safeguard in 17.1c, which says even if you haven't filed it in time with the International Bureau or with the receiving office, you still have an opportunity to furnish the priority documents to the designated offices. Whether that's really an extension of time, it actually means a lot more work because you have to file potentially the original priority document to each and every designated office where you enter into the national phase. So I'll leave that up to your own debate, whether that's an extension of a PCT time limit or not. A last item I mention here is a question about when you file a demand. And when you file a demand, which arguably not many applicants do these days anymore, we're down to about 3% of applicants still filing demands. But if you do file a demand, our recommendation is that you always file amendments or arguments together with the demand to convince the examiner at the IPA to issue a more positive final report than maybe what you have seen in the search report and written opinion. But sometimes you're up against the time limit. You know you need to file the demand, but you're not quite ready with the drafting of the actual amendments that you would like to submit. So one little trick here that you can do is you file your demand, you tick a box saying, I'm submitting Article 34 amendments to my claims and description with my demand, but you don't actually attach those amendments. What happens then is before the IPA can start doing the work on your application, they would first have to invite you to furnish the missing amendments. And effectively, they need to give you a reasonable time limit to submit these amendments. And hopefully that would be at least a month. So you could effectively extend the time limit to file your amendments in this scenario for an additional month by doing this. Sounds good, but it will also lead to a delay in issuance of the final report. So I really would urge you not to do this unless you absolutely have to, because very likely then you end up getting your IPRP Chapter 2 very late. And that's really not good for the applicant because you want to see that report before you enter the national phase. So it's really a last resort if you're late in producing and drafting your amendments. Okay, so after some discussion on possible amendments, possible extensions of time limit, I now want to have a brief discussion about what happens if you miss a time limit. And of course, if you file a lot of PCT applications, one of these days it's bound to happen that you miss a time limit. So I just want to give you a quick overview of some of the main provisions that help if you do miss a PCT time limit. So arguably not a PCT time limit, but a time limit under the Paris Convention is the 12-month priority period to file the PCT. If you miss that time limit, there is, of course, the possibility to request restoration of the priority right. This is a request that requires an explanation as to why you missed the priority period, and it's not a given that it will always be accepted by the receiving office. But it's a possibility if it does happen to you that you file your PCT application a little too late. You can only max be late by 2 months at the end of the priority period. If you're even later than that, it's not possible to restore such a priority claim under the PCT regulation. So this is all governed by Rule 26 bis point 3. If you don't do it up front with the receiving office, you can actually also restore the priority right once you enter the national phase. But that's, getting us into too many details. The next two rules I'm mentioning here is Rule 82 and Rule 80.6. Those are actually rules that really have worked and had a lot of purpose in the paper world, but today we're not really in a paper world anymore. Most of what you submit is probably in electronic form. So loss in the mail is loss in the paper mail, and that really does not apply to electronic submissions. But for completeness sake, I did want to mention those two rules. There's a possibility if something gets lost in the mail, and you can prove that it was lost in the mail, you did, mail it, and you have a receipt of mailing it, then possibly you can ask for an extension of a particular time limit. Or the reverse, if something comes from an office, but it's dated on a certain date, but it gets to you more than 7 days later than the date that it bears, you can also get an extension of the time limit, which applies for you to respond to this incoming document. Again, not so relevant today anymore because we both applicants and offices have moved quite a bit to submitting these things by electronic means. 82 quarter is a general rule that unfortunately only applies to time limits within the PCT. So it excludes the priority period, and unfortunately it also expressly excludes the time limit to international phase, but otherwise applies to all other time limits within the PCT. So correction of priority claims, response to invitation to correct formal defects, furnishing of a priority document. All of these things regulated in the PCT could be subject to 82 quarter. And if you have a case of a force majeure, act of God type of event, you could ask for an extension of this particular time limit. Now, obviously, the downside is force majeure is a relatively rare and heavy thing to happen, and we don't really want these things to happen. Still thinking of the not so far away pandemic that we had to go through, and natural catastrophes of any sort are also not something that I wish upon anyone. But these are the kind of things that would, in principle, allow you to extend certain time limits. So if you are in a situation where something like that happens, I mean, do take a look at 82 and see whether it could apply. Maybe more relevant in practice is the next rule, 49.6, which is reinstatement of rights if you have missed the time limit to enter national phase. So there is a minimum guarantee that all officers should, in principle, apply this, and there are particular time frames under this rule. It's basically 2 months from the date when you realize that you missed the time limit, or 1 year from when you should have entered the national phase. Unfortunately, between those two time limits, hey, and again, it's a combo time limit. It's in this case the time limit which expires earlier, so it can be as short as 2 months in many instances. So be careful with that. The good news is national law often provides for longer time limits, usually also for hefty fees if you are late with certain things, but at least you can reinstate maybe your application if you missed the time limit to international phase. And this is the point I mentioned earlier in one of the questions that was raised in the Q&A. Can an office review a decision, a designated office review a decision taken by the receiving office, by the International Bureau? And the general answer is yes. And I listed some of the most important provisions in this regard. And I think the rule of thumb to remember for all of us is that DOs, or designated elected office, always have the last word. So if anything was declared withdrawn or not acceptable during the international phase, you can always ask the DO to review that decision and to come to a more positive finding, at least for their purposes in the national phase. Procedurally, it's of course a big hurdle to take, because you have to ask for a review by each and every designated office where you enter the national phase. But it's good to remember that if something didn't work ideally for you during the international phase, you can still try your luck, so to speak, in the national phase and come to a more positive outcome based on national law applied by the designated or elected offices. Okay, so before I move anywhere else, I'm gonna go back to the Q&A and just check if there are any more questions. Yes, hurricanes, floodings, those are some of these force majeure events, which again, I hope we won't see too many, but it seems yes, they are a regular occurrence, and that could be a situation where you could rely on 82. Please, can you send your presentation? Yeah, I think I forgot how this works. Either we make the presentation available directly on our website next to the recording, which, by the way, will take maybe a few days to do that. So it might not be immediate, but it will be made available to you. So not to worry. Okay, and I don't right now see any other questions. And I'm actually going to be done early here. Wow, I'm a little shocked now. Okay, all right, thanks. There's someone who asked a question. What's DOEO? Yeah, sorry, those are the acronyms for a designated office and an elected office. The difference between designated office, elected office is whether an applicant has filed a demand for international preliminary examination, which I said is today more the exception than the norm. And if you file demand, then basically the designated offices become elected offices. They're still the same offices, but they get a different name, and it signifies that a demand has been timely filed, and as a result, we call them elected offices. And designated offices, I hope that term is clear to everyone. Those are all the offices you now automatically designate when you file a PCT application. It's essentially all of our contracting states, but some offices have closed the national route, so I guess we don't count them as designated offices. If an office is closed the national route, you have to go to a regional office when you want to enter the national phase. Okay, there's another question. Please, can you let me know what is the deadline for receiving an international preliminary on patentability? Okay, I can go back to that. Let me just go back to my slide here on the timeline. So if you look at that, you basically see here a time limit of 28 months. That is what we indicate as the time limit for the IPA to issue, well, here the International Preliminary Report on Patentability Chapter 2. However, that requires that you have filed your demand in time, so at the latest 22 months, and that you have paid all the fees within the time limit so that the office really had the allocated time to issue the IPRP Chapter 2. It does unfortunately happen in practice that sometimes things are late, either on the side of the applicant or on the side of the office, and the 28 months is not really respected in all cases, which is a shame, because the idea of the system is, of course, that you get the report out of the Chapter 2 procedure at 28 months, so still before you need to enter national phase, and you can look at it and then base your further decisions on whether and where to enter national phase on the findings in that report. I hope that answers this question. And I think that exhausted pretty much all the questions that I can see. Okay, and there is actually information also in the chat on where you can find the recordings of the other series. So thank you very much. Oh, someone is still raising their hand again. I don't think we can do that. Okay. As I was trying to say, we're done. I see there's one other question coming up, and it says, please explain PPH. I can do a very, very quick explanation on PPH. So PPH is basically something which is not as such regulated in the PCT, but it's bilateral or multilateral agreements between some of our contracting states. And they have said that if someone can show to them that a positive office action or a positive decision was already taken by one office, if they participate in PPH, would be willing to pick up that application out of term and process it more quickly than other applications. And so it's basically a possibility when you enter the national phase to speed up the national processing of your applications. By the way, it also applies outside of the PCT, but that's at least a quick and dirty explanation of PPH, probably not really sufficient to explain everything, but there is quite a bit of information on our website. So please take a look at our website, and if you have more questions, get in touch with us by email. And I'm going, oops, there was one thing a little too quickly. I did want to show you the last slide, actually. Where here you have contact information, so please reach out to us. And I'm, of course, very much looking forward to seeing you again for the next episode, which I will not do. There will be colleagues from who are much more knowledgeable about ePCT than I am, about the details and all of that. So they will do the next episode, and then I'll see you back with the 5th episode. And right now, I don't even know what this is going to be about, but I'm sure it will be about another fascinating topic on the PCT. So thank you very much for joining us today, and see you next time. Thank you.